So last week we talked about listing agents and what you need to focus on as a listing agent. Dana, not a problem. This week we're talking about buyer's agent and what you need to focus on as a buyer's agent, right? Last week, there are some provisions, a couple new ones, but there are some provisions in this contract that the interpretation of it and the effect of it is different, whether you based on if you're the buyer or the seller. So a couple of them, I say maybe 8 out of 10 are going to be the same, but watch when you look at it again from the buyer side, you're going to say, oh, that's different. I didn't expect it that way. So we start out, this is, who is your seller? We talked about this last week. This doesn't change. And so if you missed last week, you need to hear it again. Understand that a contract is only enforceable against the party who has executed the contract. And so if Julie and Anne-Marie are owners of a property and you only have Julie execute the contract, guess what? It's not enforceable against Anne-Marie. And Anne-Marie is going to say, well, lovely that Julie thinks we're in a seller's market, but I'm holding on. I want to hold on to it for a little bit longer. And so I'm not selling my property. Now, granted, you're not going to make it to closing, not to the closing table or even close there too, without being notified of this, because once the title commitment is run, the title agent is going to come back and say, well, I see Julie, but I also see Anne-Marie. So you all want to go get Anne-Marie so she can sign this contract as well? So with that being said, if you're new to the business, one of the resources that are generally used in order to confirm who your sellers are is the property appraisers page. Go there, you'll see who's listed as your owners, and those are the people that you should expect to be signing your listing agreement as well as your purchase and sale contract. Can't blow over that because it's so important. This is also important, again, like we talked about last week, when you have a probate, who's your seller? If it's held in the name of an entity, now you have the entity. Let's say, for example, it's Title Xperts LLC, right? Who's supposed to be signing on behalf of Title Xperts? You can look at Sunbiz and say, okay, well, this is the manager, this is the owner, this is who should be selling on behalf of Title Xperts. George's question is, isn't the deed better? You can look at the deed. Generally, the deed is going to have what the property appraiser has. So you can look at both of those. All right. Also, just to take it a little step further, George, it could be different, like we talked about in the extent of a probate. Your deed is not going to say the estate of, but the property appraiser will, right? Let's say Jane Doe passed away. If you go and look at the last recorded deed, it's going to show Jane Doe. That's fine. That's what the last recorded deed says. But the property appraiser knows that Jane Doe is deceased. So the property appraiser's page is going to say the estate of Jane Doe. Does that make sense? They're going to take it a little bit further in the event that there's some discrepancies or some other there's some other events that have occurred since that last deed was recorded. Good question, George. Y'all keep them coming. I like it. Y'all want to be title experts. I mean, come on. All right. The second term, what personal property is being sold? This is huge. So last week we talked about oftentimes the seller, they're more concerned about what they did not intend to leave behind, right? And so we talked about light fixtures, specifically the chandelier. That's a light fixture that stayed. For our buyer's agents, what's most common that you need to be aware of is what? Let's look at the personal property that's being conveyed. Somebody's going to put it in the chat in a second. I already know. Starting at line 15, it says, unless excluded in paragraph 1E, I'll let someone in, unless excluded in paragraph 1E or by other terms of this contract, the following items which are owned by seller and existing on the property as of the date of the initial offer are included in the purchase. Range, oven, refrigerator, dishwasher, disposal, ceiling fans, intercom, light fixtures, drapery rods and draperies, blinds, window treatment, smoke detectors, garage door openers, security gate, and other access devices, and storm shutter panels. Other personal property items included in this purchase are What's not included in this list that you would expect to be conveyed is the legal term upon the sale of the property. Exactly. Washer and dryer. I knew someone would drop it in the chat. Washer and dryer. Buyer agent. Make sure if the parties intend, which generally they do, for the washer and dryer to be conveyed with the sale of the property, the home, the real estate, that must be included in that section. Don't assume don't assume that anything that is not listed in paragraph 1D is going to be included. If it's not listed, it's not going. Washer and dryer is not there. You have to put washer and dryer. And let's be more specific. Let's put the make, model, design, the color of the washer and dryer. For example, you would hate for a stainless steel LG to be replaced with a white Whirlpool. I don't know. Whirlpool better than LG? I don't know. I know you probably want stainless steel more than white, so we'll say that, right? So you want to specifically say stainless steel, front load, washer and dryer, or LG washer and dryer. All right, don't miss that, guys. That's a rookie mistake. Put that out there. All right. Third point, do you have a sufficient inspection period? Now, I know in this market, people are waiving inspection periods. They're doing, 5-hour inspection periods, 2-day inspection periods. So be it. If it's sufficient for your buyer, and again, I'm going to put a pin there and say this, guys. Be sure that the offer that you draft, that your buyer fully understands what you've drafted. Unfortunately, we are seeing buyers who have executed a contract and there are terms that they clearly agreed to by virtue of executing the contract that if they had understood what they agreed to, they would have never agreed to it. Does that make sense? So no inspection period, an additional escrow deposit, all these things that make the offer more appealing to a seller, which I get it, but if the buyer cannot perform, they're being put in a very precarious place. So although you may have learned how to do this super sophisticated and very desirable offer, if your buyer cannot perform, don't just draft it up and slide it in front of them and say, well, we'll figure it out later, because guess what? Now we are in liability city. So back on the road, inspection period. Make sure that you can perform your due diligence, your inspection of the property during that time. Now, the other point I want to make about that is if during the inspection you identify some significant, I suggest, structural issues, I suggest that you extend the inspection period until those structural issues are resolved. Don't say, hey, so we know the roof has a, 2-foot wide hole in it, and we're going to fix that, right? And you allow the inspection period to expire, and now the roof is not repaired to the buyer's wishes. So any significant repairs, make sure they're done during the inspection period. The other point you see circled here, you guys ever notice that the last line says buyer shall be responsible for any and all repairs and improvement required by buyer's lender? So if you do not clearly, if you identify during this inspection period that there are repairs that are required by the lender that you don't negotiate for the seller to repair, the contract clearly says that the buyer will be responsible for all repairs and improvements required by their lender. So you want to be clear. Again, if during your inspection period you determine that, let's say, for example, FHA has a different, they have a heightened requirement for the condition of the property. If you determine that this property is not going to make FHA after inspection, but it can be repaired to the point where it will satisfy FHA, and you expect the seller to make those repairs accordingly, we have a writer that addresses it. Also, make sure that that information is there in an addendum or however it's necessary to be very clear that the seller will make the repairs to satisfy the lender's requirements. All right. Part 2 to that. Generally, you're going to find out about open permits and code violations from the lien search. The inspector, depending upon how sophisticated they are, they may say, well, I don't know. This house has a whole an extra 2 bedrooms and 2 baths. I don't see a permit for this. Like, we need to check and make sure that this was built up to code and permitted, right? If this was figured out during the inspection period. Guess what? Remember, the contract provides that the seller is not responsible for closing out all open permits, code violations, none of that. They're not responsible for that, obviously, unless they agree to it. So this is where you get the language that at the end of your contract that says, seller will be responsible for closing out all open permits and curing code violations at their expense prior to closing. Where does the at their expense comes from? Look at line 275 that I've circled here. It specifically says in the contract, seller shall not be required to expend or become obligated to expend any money. It says it. So this is why that language is included in your additional terms. And I'm going to repeat the language. It simply says, seller will be responsible for curing all code violations and closing all open permits at seller's expense prior to closing. At their expense, because again, we're all like best friends now. George and I are best friends now. We're under contract, and then as soon as we found out that it costs $5,000 to close out an open permit, and George goes back and points at line 275 and says, well, I'm sorry, this contract clearly says that the seller is not responsible for the cost. Now we're not best friends anymore. So let's go ahead and make it clear from the beginning that seller will cure all code violations, resolve all permits at their expense prior to closing. Again, that's another rookie mistake. You shouldn't make that mistake. If you don't have that in your contract, that's a rookie mistake. So what do we talk about? We talked about the washer and dryer. We talked about the language that seller will cure all code violations, close all open permits at their expense prior to closing. This is another big one. Point 5. Are tenants remaining in the property after closing? We talked about this last week with regards to the seller. Here's what you need to know, buyer. As buyer's agent, you're representing the buyer. I'm going to assume there are tenants in the property, and I'm going to assume that you are, you intend for this property to be an investment, even if it's in the short term, even if there's only 6 months left on the lease. You anticipate that you're going to receive, let's say, $3,000. Seller told you they're collecting $3,000 in rent per month from the tenants in the property. Make sure that you obtain the lease to the property within 5 days after the effective date, so that the buyer can confirm that the tenants are in fact paying $3,000 per month in rent. Believe it or not, guys, I had a deal, wasn't my closing. We got it on the legal side. No lease. No one got the lease. No one updated the settlement statement for the rents that have been paid or the security deposit that had been collected. Legit. And it was a commercial deal. How's that happen? Make sure you get the lease or leases, so that your buyer can review the lease to confirm that they agree with the terms of the lease that's in place. If they don't, they can just cancel. They need to make sure that they exercise their right to cancel. Okay? If you got any questions, let me know. Now, the second part of that, point number 6, is make sure that the settlement statement is updated with the prorations. We talked about this last week with regards to the seller. If the seller says a 5-unit building, each tenant had provided to the seller when they moved in $5,000 as their security deposit. 5 times 5 is $25,000. that they're going to be looking for when they move out. Buyer needs to be credited that $25,000 so that they can return that security deposit to those tenants when they move out. Don't miss that. Once you close, guys, it's hard to get money out of people once you've already left the closing table. All right. So you immediately, if you represent a buyer and there's tenants in the property that they're purchasing, you immediately want the leases. If it's multiple units, you want an estoppel letter, which is confirming what the seller is telling you. The seller says, I collected $5,000 in security deposit. The rent is $2,500 per month. You want an estoppel letter signed preferably by the tenant, affirming that they have $2,500, $5,000 in security deposit and $2,500 per month in rent. So that you don't have a situation where we've closed, we've given keys, given checks, and all of a sudden the tenant is saying, no, I had $10,000 in security deposit and I only pay him $1,500 per month. Like, sorry, I don't know what you're talking about, right? So that's point number 6. Doozy. Let's slide to number 7. Financing. This one, oh my gosh, I don't see this as much as I used to see it, guys. But please do not leave this section blank. Obviously, section B, 8B. If it's cash, 8A, fine. You guys know what that means. Buyer will pay cash for the purchase of the property. In the event that the buyer determines that they no longer want to pay cash, this is what's happening in this market. Let's say, for example, you make your offer for cash, knowing that cash is a favorable offer that's probably going to be accepted, knowing that the buyer is really, in fact, trying to obtain financing, but you simply don't want to make the contract, the offer contingent upon financing. You can do that. But just know, as stated here in the contract, in the event that that's the selection that you make, the buyer can then go and get their financing, but they're not going to be able to cancel the contract because their financing fell through. Well, they won't be able to cancel and get their deposit back. I'll put it that way. You can cancel, but you're not getting your security deposit back unless some other agreement has been made, if it's on the basis of not obtaining financing. So I'll make that clear. In this market, we're getting it. People making offers, a cash offer, knowing that they're going to get financing, they're trying to obtain financing. Something you can do. Just understand what your buyer has agreed to. Now, if you're already in 8B world, you know you're getting financing. Let's read it. Starting at line 86, this contract is contingent upon buyer obtaining approval of what type of loan? And let me point out here. Here's another thing. You guys remember the contract class and I told you about the little asterisks beside the numbers? The asterisk indicate where there is a blank that should be filled in. Guys, fill it in. If it's not relevant, put NA. Right? Believe it or not, we'll get contracts, 8B, rest of the financing information left blank. Guess what that means? You left the buyer wide open. They have no parameters. Let's say the buyer wanted FHA. Buyer does not qualify for FHA. They got to go conventional. What does that mean? That's more money down, right? But because nothing has been selected, you're stuck. You never said you wanted FHA. You actually just left it blank to say whatever you got is what you're going to take, right? That the loan approval is 30 days from the effective date. That's usually not so much of an issue. Here's where it gets, the rubber meets the road. Line 89, leaving the interest rate blank. What does this say? It says, we'll start at line 86. This contract is contingent upon buyer obtaining approval of a conventional FHA, VA, or other loan within however many days after the effective date for a, what is it? Is it fixed? Is it adjustable? Is it fixed or adjustable? At an initial interest rate not to exceed blank interest. What is the interest rate? And it says, if left blank, then prevailing rate based upon buyer's credit worthiness. What does that mean? That means if you have a 400 credit score and you are being offered an 8% interest rate in this 2.5% interest rate market, that's what you're getting because you never put a ceiling there. Work with the lender. The next question I always get, well, what should I put? Work with the lender. I know you're not driving people around that haven't spoken with the lender yet. And so there should already be a pre-approval. Ask the lender, what is the rate that we're looking at? And I suggest that you bring it down a little bit. Let's say lender said, oh, they have, 840 credit. They're going to get 2.5%. I suggest you put 2 or maybe 2.25. Give yourself some room. Now, obviously, the listing agent that we talked about last week has to accept that, but give yourself some room and give yourself an opportunity to jump out of this contract if necessary, because they have not gotten the financing that they were looking for. All right. Now, the loan approval deadline. We talked about, again, if it's left blank, then it's 30 days. Guys, do not. I mean, only thing I want to tell you about this is don't blow this deadline. If you are communicating with the lender, your transaction coordinator, whomever works with you, if you're coming up on this deadline and you don't have a loan approval, you need to start talking about an extension. Or if you've already extended 4 times already, do we need to cancel? Whatever the case, do not just allow this loan approval deadline to expire, because generally that's your last out to get the buyer's commission. Get their escrow deposit back, right? Don't blow the loan approval. No ifs, ands, buts about it. Well, what about that? Listen, do not blow the loan approval deadline. You have to stay in contact with the lender. Do not allow the lender to send a loan approval that has 10 conditions. We're back at square one. Let's make it a reasonable loan approval that we know we're going to ultimately get a clear to close, right? Very important. What is that, guys? That's a rookie mistake. Missing the loan approval deadline is a rookie mistake. Don't do it. Now, 9, did the property appraise? In this market, we already know. Did we expect it to appraise, or did you already know you were doing, 100% over, or 10% or 50,000 or 100,000 over list price and appraised value? Who knows? Whatever. But here's what I want you to know. Last week, we talked about this provision, and we talked specifically about at line 119 that in the contract, there is in the contract a provision that allows for the buyer to cancel the contract in the event the property does not appraise, it's insufficient to meet, it says specifically, appraisal of the property obtained by buyer's lender is insufficient to meet the terms of the loan approval. We talked about that, right? What is that? It says it there. If the loan approval is not sufficient, then you can cancel the contract. Not even 15 minutes after, got this text message and we talked about seller rep last week as well, right? Because we were talking about the listing side. Not even 15 minutes after the class, I got this text message. This is the seller's attorney saying, strike that provision. There will be no cancellation of this contract in the event that after the loan approval period, this property does not appraise. Guys, I don't make this stuff up. I almost fell out of my seat. I was like, oh my God, he went right. He told you specifically which ones to strike through. Now, obviously, I said, you're not striking through that, right? And she says, of course I'm not striking through. But again, this just goes to show you that there's a provision there that allows the buyer to cancel the contract after the loan approval if the property does not appraise, thereby causing it to not be sufficient for the lender's requirements. Now, as was indicated, I do agree with him. It could be a little vague, and it's also something that most people have never touched on. So should you attempt to utilize that? No, I suggest that you not, but I suggest that you know. Similar to the CFPB built-in extension. We talked about that in the contracts class. There's a built-in extension for if the lender does not meet the requirements, the timing for funds to be available under the disclosure period. It's built in. Should you just rely on that? No, you should say, hey, we're not gonna be able to close on the 30th because the lender is not gonna meet their 3-day disclosure period. Let's do an extension. Let's do an addendum extending the closing date or whatever's necessary, right? The provision is in the contract, but it's better to be clear than have confusion. So you guys know about that. If you're the listing agent, you're probably asking for it to be stricken. If you're the buyer's agent, you are not striking it. You are using it. You want everything that you can. I mean, if that's what the agreement is, that's what it is. If it needs to appraise, it needs to appraise. All right. Now, finally, has the buyer defaulted? Has the buyer defaulted? And this is something we talked about 2 weeks ago, maybe, talking about the escrow deposit. Who's keeping the escrow deposit? Let's look at what the contract says under if the buyer for buyer default. If buyer fails, neglects, or refuses to perform buyer's obligations under this contract, including payment of the deposit within the time specified. Remember we talked about that, including failure to make the deposit. That's a default. The seller may elect to recover and retain the deposit for the account of the seller as agreed upon liquidated damages. Liquidated damages means that's the extent of what I lost. We'll go ahead and agree that your escrow deposit was my loss. That's what we call liquidated damages. Consideration of the contract and in full settlement of any claims whereupon buyer and seller shall be relieved from all further obligations under this contract. Or, this is what I want you guys to know. Again, you don't give legal advice to your clients, but know that. See line 329? Or seller at seller's option may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. What does that mean? That means the seller can sue the buyer. They can file suit against the buyer. And it's not just the escrow deposit. It can be a larger relief. Let's say due to, they say damages, right? Let's say, for example, they said $5 million property. Let's say the buyer under the contract was obtaining financing. Financing fell through. We're past the loan approval period, so there's no discussion about there being a contingency for that. And the seller feels like, okay, and let's say the seller gave 2 extensions, 3 extensions for the purposes of a hypothetical. Seller has foregone other offers. They've done all these different things to allow this buyer to stay under contract. For the buyer to ultimately say, you know what, we're not going to proceed. And the seller says, this escrow deposit is not enough. I'm suing them. Like, that's it. Obviously, they need to go through mediation first because we know that the contract says mediation first. If it's not resolved, then we go to litigation. The point is, know that it does not have to stop at the escrow deposit. Seller can file suit for additional damages. It's a breach of contract at that point. Right? Has the buyer defaulted? So, recap. What's the rookie mistakes? I want to make sure that we don't make the rookie mistakes. Rookie mistakes. Appliances or any other fixtures. Anything that's supposed to stay, make sure you grab it. What else? Inspection period. Making sure that you have in the contract, if you represent the buyer, seller will be responsible for closing out all open permits, curing all code violations at their expense prior to closing. If you don't have it in there, rookie mistake. Third, loan approval. What's the loan approval deadline? What are the terms of loan approval? Don't leave it blank. What is their max interest rate, and put a little bit less than that. If you leave that blank and now you leave the buyer wide open for whatever terms the lender throws out, rookie mistake, right? Loan approval deadline. What is the deadline by which we need to be sure that the lender says, okay, we're all good. All we need are these few conditions, for the clear to close. If you don't get that, rookie mistake. We can't have that, right? All the other terms, and I'm going to go ahead and include to not strike that provision. Don't strike that provision regarding the appraisal. It's in there for a reason. Sylvia has a question. Seller rushed at buyer's request to close timely. Pods were ordered, storage facility was rented, buyer didn't sign. Ooh, last two loan contingency, buyer defaulted, house never closed, seller did not extend. Where does the agent stand in reference to all their work? That's a very good question. Right here. The portion of the deposit, let's say that you obtain the deposit back. The portion of the deposit, if any, paid to the listing broker. We're going to assume that the buyer's escrow deposit is retained and given to the seller. It says the portion of the deposit, if any, paid to the listing broker upon default by the buyer shall be split equally between listing broker and cooperating broker. Sylvia, that's where your work is. Provided, however, cooperating broker's share shall not be greater than the commission amount listing broker had agreed to pay cooperating broker. Now, what that means is, let's say, for example, let's say the commission was $10,000. Let's use that as an example. The escrow deposit was $40,000. Half of that is 20 and 20. 20 is more than the 10 you would have received in commission. That's what that last line is saying. But outside of that, that's where the agent's compensation comes from in the event that the deposit is retained and awarded to the seller. Neither party is signed and released, deposit held by buyer's attorney. That happens. We talked about this in a couple classes. So there's a process depending upon whose deposit held by buyer's attorney. I'm sorry, going to your So in Sylvia's question, the deposit is held by the buyer's attorney. The buyer's attorney, Sylvia, they have a protocol that they must follow. And that is they're going to have to, unless they want to continue to hold it. So first, the pursuant to the contract, what is the first step that you take in dispute resolution? Mediation, unless some other provision has been, agreement has been made. The first step is mediation. And in the event that mediation is not successful, then you proceed to litigation. That's what's happening on the buyer and seller side. Now, at the same time, the buyer's attorney may decide that they don't want to hold the $50,000 in their escrow account. They want it out of their escrow account. They're going to place that money, those monies in the court registry, and they're going to file what's called an interpleader action. And that is where when you interplead, you bring pleaders into the action. They're going to say, here, court, here's $50,000 related to a purchase and sale dispute. I'm bringing in this buyer, I'm bringing in the seller, help them to decide who is entitled to this $50,000. Now, one caveat is it's going to be a little bit less than $50,000 because the attorney is going to be able to reduce the filing fee and their reasonable attorney's fees for facilitating that process. 24K seller, that's what you requested, that's fine. But again, they have to agree. All right. Let me know if that answers your question. The seller can, the buyer can, either party can. You should just, whomever is most pressed. If I were the buyer, that's my $50,000, I would be starting the process. Because at the end of the day, the contract provides for, with regards to mediation, they're going to split the cost of mediation anyway. The cost for the mediator is going to be split. If they have representation at mediation, attorney representation at mediation, they're going to pay for their own costs for the attorney, but they're going to split the cost of the mediator anyway. So even if I initiate it, you're still going to have to pay half the cost. So let's just go ahead and get this party started, right? The realtors do not have the authority to initiate a dispute. So that's not it. And everyone is silent. So I'm assuming, Sylvia, that that means your client is silent as well. So that means you can have a conversation with your client about that. And this is a very good question. You cannot force the parties to proceed. And it's not held by, the escrow deposit is not held by, here's the provision, Amelia. The starting at well, it starts at 116 a million, but specifically at subparagraph 3. Sylvia, you cannot initiate it. You're welcome. You cannot initiate it. You're a realtor. If the deposit was held by a broker, a real estate broker, they would get FREC involved, and they would start the process that way. An attorney can start the process again by filing the interpleader action. But even with regards to the interpleader action, the court is going to say, well, let me see what the agreement is. The purchase and sale agreement says you must go to mediation first. So the court could force the parties to go ahead and schedule mediation. Good questions. Y'all see how this legal stuff works? But yeah, that's tough. I know you want to be compensated at this point, but that's essentially, I wouldn't say leave it alone. I would say keep going. Encourage the buyer to file the mediation, as well as if you represent the buyer, then I would encourage the buyer's attorney to file the interpleader action. But again, you got to be, if you represent the seller, you definitely want to go ahead and proceed with the mediation. All right. Sorry, guys, I'm responding to Sylvia. She's sending me the message. So the seller is not responsible to converting back garage from a non-permit bedroom unless it's noted in the additional terms. Absolutely. Nope. If that's what it's going to take to cure a code violation, well, the permitting code violations come up in your they often come up in your title search, and you know that title search, that is necessary. That the seller has to resolve the issues that come up in the title search. So they could come up in the title search, but they generally come up in the title search if they've already started accumulating monetary fines. So prior to that, then they're only on the lien search. In the lien search, the code violation still must be resolved. But if it's a permit issue, then open permits don't have to be resolved for title. Does that make sense? Open permits are not title issues, but they are an issue if the parties have agreed by virtue of language in the additional terms that open permits, expired permits will be resolved. No, Janet, there's no, not too much liability. No. Listen, all you do is learn. You learn, you ask questions, you make sure you rely on your broker, your attorneys that you work with to get answers to your questions. All right. All right. So if there are no more questions, in closing, our closing thought for the day: discipline, not desire, determines your destiny. So we can want all we want. We can have, everybody has the desire. Everybody wants to be a top producing agent, right? Everybody wants to be $1 million agent. Everybody wants to be, $1 billion producer. But it's the discipline, not the desire to do that determines your destiny. And so what are some of our disciplines? Some of our disciplines are coming here each Tuesday and getting the content, getting the training, getting the coaching that's necessary to answer the questions and provide clarity that you will, as we talked about last week, competence. You become competent, and competence generates confidence. So what Janet just said was spot on. It said so much liability, it scares me. Well, listen, guess what? Because you're hearing about some of the things that you were not necessarily competent in, and that's fine. I hear stuff too. I'm like, oh, wait a minute. I got to go read on that. But once I read up, once I have my notes, once I have a plan of action, plan of attack, now I'm confident. And it takes practice. It takes practice. We do this day in, day out. Eventually, you will know this contract like the back of your hand. Competence creates confidence. And then discipline, actually doing the work. Not desiring the outcome, but doing the work that generates the outcome is what's going to determine your destiny. All right. So discipline yourself, guys. Discipline yourself to show up, to be where you need to be, to gain the competence. Remember last week we talked about outside the box education, outside the box results. Outside the box education, outside the box results. If you do what everybody else is doing, you're going to get what everybody else is getting. If you do the things that the top producers are doing, you're going to get the results that the top producers are getting, right? Discipline, not desire, determines your destiny.